Electronic boards being set up in the courtroom by P2B's legal team for today's hearing at the ongoing Presidential Election Petition Tribunal. They will continue to tender evidence and call witnesses today. Earlier, the presiding judge reprimanded Tinibus counsel because of his consistent objection to everything in court. In fact, it has become a chorus every time: objection, objection, objection by the trio of Inec, Tinibus and APC counsels, to the extent that they even objected to the tendering of evidence of results that Inec used to declare Tinibus winner. Anyway, the judge had to caution Tinibus counsel because of their persistent objections, and as the judge put it, they are using frivolous tactics to manipulate the proceedings. How can they be objecting to the tendering of Inec issued appointment letter to a presiding officer without stating the reasons immediately? Now, let's hear the full transcript of today's hearing. Let's quickly jump the presence of different representatives. As usual, P2B was in court and Levi Esayan stood up. "My lord, we have a witness who is on subpoena, and I will hand over to Okutepa Esayan, while Ikweto Esayan will lead the technical team and software presentation. Today will be hot." Immediately the mic was handed to Ikweto Esayan. He said, "My lord, we have two sets of subpoenas that were served Channels TV, and I will start with the witness that came on subpoena, and he came with his witness statements of oath, which we have filed." Court now asks the witness to identify himself. "My name is Lucky," said the witness. LP counsel stands up. "My lord, this witness was subpoenaed on 30th May 2023 and 6th June 2023. Witness, do you have the two subpoena?" "Yes," he responded. "Where are they?" "They are with me here," responded the witness. The other LP counsel now addresses the court. "My lord, we seek to tender the two subpoena addressed to the MD CEO of Channels TV, addressed on the two dates issued by this honorable court. In their usual manner, objections were flying everywhere, but this time there's a difference. Maybe because of the earlier reprimand that Tinibus counsel got from the judge. They are stating the reason for their objections this time around." Tinibus counsel spoke first. "Our objection is based on the competence of this witness to testify on the proceedings. Our objection is invested on the provision of the Electoral Act. My lord, it is settled that a petition must be filed within 21 days of the result of an election. My lord, the document that should accompany a petition should have been filed, and the petition must be accompanied with the witness statements and oath, blah, blah, blah." Tinibus counsel is trying to convince the court that this witness shouldn't be allowed to testify, and that they weren't made aware of the video presentation, that the name of the witness is not in the petition, but the Labour Party counsel is already making counter-arguments. I even cited an election dispute, Ararume versus Inec, and another one to prove his point. The Inec counsel counter-argues by mentioning one case and told the judge that Levi Esayan was involved in the case. At this point, the presiding judge said, "How does it matter who was in the case you're citing? You're wasting time. We want to watch film." This judge. While the respondents have a right to object to the admission of a witness in the court, the ultimate decision lies with the court. If they feel the witness is vital to the petitioner's case, they will allow the witness to stand. The respondents also use this back and forth argument to waste time, like the presiding judge said, and the Labour Party are in their second week of evidence and witness presentation. They have 1 week left, and they have to squeeze in everything within this time frame because the court will not extend it. While both learned gentlemen were arguing, the APC counsel added his voice. "My lord, there is no difference between subpoenaed witness and ordinary witness. I join my colleagues to object and cite some cases like ADP versus Inec. The presiding judge doesn't agree with him. You're wasting time. You're citing what has been cited already. There's no time," the judge told the APC counsel. "I want my lordship not to adopt the application of this witness, and it should be refused. The timing for this testimony has elapsed," concluded the APC counsel. Meanwhile, it looks like the LP counsel has a superior argument. He said, "My lord, subpoena is an order of the court issued to the witness, and either plaintiff or petitioner has no command over. On paragraph 41, subparagraph 5 and 6 of the fourth schedule of the Electoral Act 2022, to submit with respect that even when a witness statement was not front-loaded with the petition, the witness can be allowed to testify in this honorable court." The other Labour Party counsel also added his voice. "These learned gentlemen are on fire. He cited an election dispute, Oni versus Fayemi 2019 Supreme Court judgment, which states that the rules of the court cannot override the rule of fair hearing. 219 witnesses came on subpoena to testify. He also confirmed that the names of the subpoenaed witnesses are actually listed in pages 42 of the Labour Party's petition. Okutepa SAN wasn't finished. He told the court, this witness is before this court on subpoena, and by the authority of Lasu versus Owoyemi, the APC council interrupted him to correct the year of the matter and the pronunciation of Owoyemi, which made him to tell the judge, my lord, you see they know it, and they didn't cite it. They know it, oh. It was cited yesterday, so even if they hide it, I already know it, added the presiding judge. The LP council now correctly pronounced Lasu versus Owoyemi.
Okay.
You said Lasu and what? The judge jokingly asked. Owoyemi repeated Okutepa SAN. I thought you said Okutepa. My lord, I don't have a case yet, replied the LP counsel. And he wasn't done. He continued. I also want to cite Tajudeen Bello versus Odofin 2021 Law Pavilion Electronic Report. Also in the case of Amachere versus Inec, the court held that no witness should be held back when subpoenaed. A subpoenaed witness by authority can testify orally. What injury would we suffer? No injury would be suffered. And my lord should overrule this objection and to hold that this is technicality taken too far. And they are doing so to run away from the punishment that they know they will suffer. Ha! This is brilliant. INEC chairman was speaking about this and the judge interrupts the LP counsel. No, stop that. Are you telling us what the witness wants to tell us? No, it's public knowledge. That's why they are all objecting like this. They are hiding from the punishment of those statements, replied the LP counsel. Please don't say that, the judge advised. And Okutepa SAN concluded by telling the court the witness is competent and can testify on subpoena, and my lord should allow us to proceed. Thank you, my lord. The reason the respondents are opposing this witness with all tenacity is because they know the weight of his testimony. After the arguments by the learned counsels, the court reserved ruling on whether to allow the witness or not, but they still told the witness to go ahead and present his evidence. Decision on the matter will be communicated at the final hearing, and if it's in the positive, that means the evidence must have influenced the judges. If negative, that means it was a waste of time. Anyway, the witness has been told by the LP counsel to go ahead and present his evidence. While he was bringing out his red flash drives, the INEC counsel jokingly said, my learned colleague is giving me red flash drive instead of blue like my Chelsea. LP counsel replied, I know Pinheiro is a Chelsea fan, so he can have a red one like my Arsenal. These guys. Even the presiding judge is not left out. You should have given him blue for Chelsea. That's why I gave him red card. But both of you are still losers. Both Chelsea and Arsenal didn't even win anything. This judge. Now the video is about to be played and the LP counsel, after asking the court for permission to play the video, Tinibus counsel stood up. My lord, objection. I object to this flash drive being played. The INEC counsel also on his feet. My lord, we are indifferent about playing this flash drive. It's already admitted into evidence. APC counsel, Oya, we stand with our colleagues to object to this flash drive being played so that we can go back to watch it. We have not played it yet to know the content and we would need to prepare for cross-examination. This evidence should not be played. They are not obliged to show you the content. Besides, it sounds entitled. That was how the presiding judge shut down one of the lawyers in the APC legal team for telling the LP counsel to sit down. The judge told him, I won't allow this in this courtroom. He had to stop his argument and sit down. One wonders why some of them are not gentle in their approach. Anyway, the LP counsel is not letting go. He said, let's watch the film first, and then you can object. Even me, I don't know what's in the clip. The respondents are still not convinced. The APC counsel said, we need to be served first before you play the video. This is an ambush. The LP counsel is not having it. There's no law that states such, my lord. We can move on and see what the witness wants us to see. After the judges finished deliberating among themselves, the presiding judge said, We will need to leave because the time is gone, and if not for time, we would have played this video. Because if it was a document, we would have moved on to listen. What's the difference with a video as long as it's from the witness? There's no difference. Honorable Justice Ugo added his voice. Exactly, none. We just wasted our time arguing. The video should have been played today. The presiding judge adjourned the matter. The court will be adjourned to tomorrow, 10th June 2023, 2 p.m.